is an affront to me as an attorney, and it should be an affront to every citizen in this country. Having said that, it's a great time to be a real estate lawyer. It's a great time to owe money to a bank or an institution because you have no idea who you're supposed to pay. So having said that, we're going to go through how we all can benefit from this crisis. It's a world upside down. It's a world inside out. But nevertheless, it's a world that we now have inherited, and we got to figure out how to deal with. So tonight, we're going to be talking about toxic foreclosures and foreclosure fraud. And this workshop is brought to you by the same folks who brought you the subprime crisis, the liquidity crisis, the subsequent mortgage crisis, and now the foreclosure crisis. And that is the folks on Wall Street, the banks, to some extent our elected officials, as well as folks who were supposed to be supervising the banks, and I would also suggest, again, the judiciary. And I say the judiciary because, to a large extent, they became a private collection agency for the banks. They would say that they wouldn't want to take sides, and therefore it wasn't up for them to make sure that the documents that were being submitted were in any way correct. I believe that a judge has an obligation to make sure that, in fact, there are certain documents, certain basic documents in a file that gives the bank even the right to be in court. And when other lawyers are suggesting that the documents are not correct, instead of trying to sweep the problem under the rug, file after file, day after day, week after week, month after month, that they would understand that they are not fulfilling their judicial oath of office. And one of those oaths, may I say, is that they are supposed to uphold the integrity and independence of the judiciary. That is their first obligation as a judge, to uphold the integrity and independence of the judiciary. And when conduct is repeated on a systemic basis, and then it is found out that the entire branch has fallen down, I think the judges need to acknowledge that they have not fulfilled their duty. And it's not just in Florida. It is across the entire country that this branch of government has been to a large extent corrupted by the expediency that has been placed upon them by other forces in the government, and also by private institutions. So let's go over tonight what has happened and how it happened. I'm going to just read off some names real quickly. GMAC, JP Morgan Chase, Bank of America, Wells, I have a question mark, and others. These three banks have already acknowledged that the documentation process that they've used in their foreclosure process is faulty. They've acknowledged that affidavits that have been signed by individuals saying they had personal knowledge concerning individual foreclosures, they had absolutely no personal knowledge whatsoever. These people who signed these mortgages were typically called robo-signers. Internally, they were called robo-signers. In addition, individuals at this bank also probably, in all likelihood, have committed fraud and perjury by having imposters actually sign documents in the individuals' names. Subsequent notaries also notarized documents that clearly weren't those individuals. Wells Fargo is suggesting they may have the same problem, and I can tell you this evening that there are many, many other banks who've used similar signers who are going to have the same problem, who have not yet come clean. This problem in the state of Florida, I previously had suggested, probably represented 10% of all foreclosures. I was told that that was too conservative a number, and that the number is probably much closer to 20% or maybe 25%. How much money are we talking about? Well, according to the Wall Street Journal this morning, they said that as much as $3 trillion of mortgages that were securitized are probably in this whole pool. So if we suggest that it's 20%, you could be talking easily about $600 billion of mortgages that may require reforeclosure or, to a large extent, deeper analysis. That is a serious, serious problem. The best way of characterizing this crisis is through Humpty Dumpty. If we consider Humpty Dumpty as the mortgage, and we think of the mortgage in historical and traditional senses of a lender says lender, you can't read it, providing a mortgage to a borrower. That is the egg. But what happens when the lender decides to slice and dice the mortgage in half? So you have two eggs, where the mortgage goes one place and the promissory note goes somewhere else. And when the note gets chopped up into little pieces or different interest tranches that you've all read about in these securitized trusts, this egg is now broken, falls off the wall. And what the banks tried to do after the egg had cracked and fell off this wall right here is they tried to put Humpty Dumpty back together again. They tried to bring the note and mortgage back, and they tried to put it back together so that they could foreclose. Because it's very difficult to foreclose on an egg when it's cracked. Now the egg cracked because there was a deliberate, intentional desire to securitize the mortgages and then sell them off into different pieces. The mortgages went to a trust, the notes went to investors, and the notes were subsequently sold to different bondholders. You've probably all heard about this before, and the details are not relevant to this evening. But what is relevant is that you cannot foreclose on a mortgage unless you put the egg back together again. But the egg fell off the wall. The egg was cracked into a whole bunch of little pieces. And so the fraud that occurred was to try and, as much as metaphysically possible, try and put the egg back together again. And the only way one could do that is by signing a bunch of bogus documents, backdating a bunch of bogus documents, notarizing a bunch of bogus documents, and having other people signing on behalf of other people. Now, we've been saying this for 2 years. We've been saying this to the courts for 2 years. And there are judges who are on record who have said, I do not want to hear it. I do not want to see it. You have 30 seconds to make your argument. I'm not going to read your pleadings. And whatever you say, I'm not going to listen to you. Okay? When a judge says that on record, okay, he has violated his oath of office. What is his oath? His oath is to maintain the integrity of the system. What's the other term you said?
Independence.
And to uphold independence. How can you be independent if you're not willing to listen to a lawyer who has done his homework, has presented an articulated argument, and nevertheless the judge says, I'm not going to listen? The other thing that's curious is when you bring in retired judges on a permanent basis, okay, to take over an entire division of a court, what you've done is you've ostracized and prevented the other judges from rotating into that division. There's supposed to be a natural rotation of judges, from criminal to civil to probate to juvenile to domestic on a regular basis. But no. We brought in retired judges just to do foreclosures. Okay? I would say that the other judges have had their constitutional rights as judges impeded upon because they are being denied the opportunity to actually rule on foreclosure cases. But for the expediency of the courts, at least in Florida, it is deemed perfectly okay to bring back retired judges who are thrilled to be paid on a per diem basis very handsomely, and who have been on record as saying that they are on a quota basis and that in 12 months they must have disposed of a certain percentage of these cases. I believe it's something around 65%. To me, it sounds like they're almost like traffic cops at the end of the month, trying to make sure that they've given enough tickets for people who are speeding. Now, at the end of the day, you can blame all these different institutions if you want. But you can really look in the mirror and blame yourself, because this is a polity, this is a government that we are in charge of. And if people don't want to get involved in the electoral process, they don't want to question elected officials during the judicial campaign, this was never an issue. No one ever asked these judges running for office, do you think maybe you would like to actually participate in this foreclosure process? Do you think maybe you should be part of this rotation? That was never a question. No one ever asked that. Most people don't even vote for judges. Most people don't even know who they are. And now the elected officials are running for office. You're hearing all kinds of stuff. There's some senators who are saying they want a moratorium on foreclosure so this crisis can be dealt with. Very interesting. But at the same time, the President of the United States, probably tonight or tomorrow, is going to sign a bill, and I'm going to write this down because I just learned about this today. It's called H.R. You should write this down, guys. H.R. 3808. Okay? I'm going to give you the White House phone number. 202-456-1111. In fact, why don't we all take a break right now and let's call it. I'm going to tell you what this is about. It's absolutely fascinating. This is the White House. Now, we have to give you a little history. Do most of you know where most of the credit card processing is done in the United States? What state? Delaware.
South Dakota.
What state, if you want to sue
Iowa.
Wrong.
South Dakota.
I believe it's South. It's where Sioux Falls.
South
Dakota. Okay.
I know.
Now, it's not a coincidence that the jurisdiction for virtually every credit card in the United States is in South Dakota. The reason is that South Dakota doesn't have certain bodies of law called usury laws. And so South Dakota decided to make a deal with the devil several years ago. They said, if you banks come in here, we will change the law, so we'll have lots of employment for South Dakota, and you can basically decide whatever interest rate you want to charge, not just the residents of South Dakota, but the entire United States. And just because the way our country is set up, sometimes one state has to recognize the laws of the other. H.R. 3808 applies that same concept to notaries. And some states have notary laws that allow for what's called electronic notaries, where in fact you don't actually have to witness the person signing a financial instrument. And if in fact you choose to process all your mortgages from that state, every